Well, a good God Saturday to you. I hope everything is going well. Karen Fletcher here, and we've got seniors navigating the change. We've got a little technical difficulty with our guest. We're trying to get him on. We can hear him, but we can't see him. And we're trying to see him. Oh, there's our guest. He has made it. All right. So, we're going to be talking today about wills and trust. I'm so glad things worked out. I mean, no, it wasn't even the 11th hour and the 59th second. We had already crossed over. All right. Well, we've got attorney Steve Lawrence with us today. And and yes, hello, and how are you?
Good morning. Good morning.
Good morning. So glad to see you.
It's
They
nice. It's
don't know
nice
what
to
we're
be here.
through.
Yes. Good morning.
Good morning. Well, I'm glad you're here, and I'm glad you're here to address some concerns seniors have. And it is definitely wills and trust. And so um, I just want to jump right into it. And did you have a way you wanted to address this first?
Well, yeah, I mean, several things, a couple of things, because I've been counseling clients on these issues for so many years. I thought one way to approach it would be to talk about some of the documents and papers
Hmm.
that are involved. And then I wanted to talk about some of the most important issues that come up. when
Okay.
I'm when I'm meeting with clients on matters concerning wills, they do most of the talking and I do most of the listening because they have information about their family situation. See, I'm a little different. My approach is different than some. On TV now, you'll see companies. I won't mention them by name, but you'll see companies that will do prepare estate documents for you for some outrageously low amount of money. And what they're doing is they're going to give you basically a set of forms that are kind of fill in the blanks. It won't provide any detail. It won't answer any questions. It'll be extremely bare bones, and it's kind of a do-it-yourself approach. My approach is different. I'm really trying to add value to trying to provide something that you couldn't provide on your own. Um, Anybody can take a piece of paper and they can write their name and some of the assets that they hold, gifts to relatives, maybe. They can sign it and they can get witness to that. And that's a legal document. But there's so many important things that that doesn't address. The reason I'm able to help people with estate planning and wills is because I've spent so many years dealing with real estate issues and dealing with property issues and dealing with transfers and dealing with guardianship and relationships, family relations and family law matters and divorce. Estate planning is not just who am I giving these gifts to. Estate planning, in my opinion, and wills, it covers a lot more than that. There are a lot of important issues that have to be addressed. Otherwise, it'll be incomplete. Yes, Karen.
Okay, so uh, before you even think about wills or trust, you should do something called estate planning.
Wills and trusts are part of estate planning. Estate planning is who you're going to leave gifts to after your death, who you're going to make gifts to during your lifetime, how you're going to deal with your affairs if you become sick, or incapacitated, who are you going to designate to make decisions for you if you become incapacitated? Who's going to make legal decisions for you after your death? And that's more than can be done on a piece of paper filling in some blanks, if you know what I mean. Okay? So you'll see these TV commercials where they'll say, we can do your will and trust, and we can do all of this for $100. Well, no, there's more to it than that. The auto shop where I go to, Karen, to get my car fixed, work done, it has a sign at the front desk. And the front desk says, cheap work ain't good. Good work ain't cheap. That's my approach towards estate planning. You can prepare a will on a piece of paper, and that's fine as far as it goes. But it won't address the real estate issues. It won't address powers of attorney for healthcare. It won't address powers of attorney for property. It won't address living wills. It won't address any of those things. Those things will be hanging and twisting in the wind, and you'll be no better off as to those issues.
Okay, I got a question. Okay, so we need to know what a will does and what a trust does, and then maybe we can determine which one we need.
What a will does, it very simply, it identifies gifts that will be made of your property, of your estate, real estate, property, cash, bank accounts, at the time of your death. That's what a will does. It's who you're making gifts to at the time of your death. A will has no legal effect whatsoever during your lifetime. It only takes effect at the time of your death. You don't need to reference life insurance. You don't need to talk about life insurance in your will. Life insurance already identifies a beneficiary. It designates a beneficiary. It travels on its own. Okay? And there are other things that travel on their own outside of a will. Some of your listeners may be familiar with something called a TOD, a transfer on death. You can go to your bank and you can identify certain bank accounts, CDs, savings accounts, and you can tell who you'd like them to be transferred to. You can identify co-signers and beneficiaries and others through your bank. And those assets will travel at the time of your death, having nothing to do with the will. Okay? So the will is not the be all and end all. It's a document that allows you, if it's properly signed, properly witnessed, and if you were of a sound mind and capacity at the time you signed it, to transfer assets at the time of your death. Let me go a little further. A will identifies several people. You're what we call the testator. You're the person who prepared the will. There's also beneficiaries under the will. They're folks, obviously, who receive gifts. I'm sorry. It also identifies a very important person called the executor. And the executor is the person you've designated. It may be a relative, it may not be. It's usually a trusted person, someone you've known for a long time. It's a person who you've identified to carry out those wishes, to make sure your final bills get paid, to make sure that final effects are taken care of, and to make sure that the gifts that you identified in your will get to the person you identified properly. Okay? That person's called the executor. Okay? So it does several different things. But there are a lot of things a will doesn't do. Again, as I mentioned before, it does not handle or address any transfers or effect of property during your lifetime. It has no legal effect until after death. Prior to death, you may want to use something we call a trust. It might be a revocable trust. It might be an irrevocable trust. but it has to do with property disposition prior to your lifetime. And yes, you can have a testamentary trust that protects assets even after your death in a trust. Here's how that comes up. Often it comes up with regard to minors and children. People don't want those minors receiving a lump sum of money after their death. What my clients often prefer is to take money or real estate, stocks and bonds, and put them in trust with a trustee who will manage those assets after death for the benefit of those children. I've written documents that say the trustee will manage these assets during the lifetime, and so long as those beneficiaries are minor children, okay? And it'll distribute certain amounts of money for their care and for their living, okay? But it's not going to give a large lump sum to a minor because there are legal issues involved with transfer, with minors having the ability to enter into contracts, sign leases, buy property, have houses, purchase vehicle. There are limitations on what a minor can do. So you might want to have a trustee, and you might authorize them and give them instructions on how you want money to get to those minors until they reach what we call the age of majority, whatever in the state, whether it be 18, 19, 21, where the minor can then take on their own affairs and sign and do things in their own name. Okay?
Okay.
That's the basic framework. The will is for after death. Often a trust, lifetime gifts are for during their lifetime. Many other variants, you can assign a legal guardian. There are people who are going to watch this who have assigned a legal guardian for those minors or others. I have clients who have assigned a legal guardian, not because their loved one is a minor, but because their loved one is disabled. They're under a disability. They're not able to handle their own legal affairs. So we'll assign a guardian to them, okay, and designate a guardian that can handle legal and financial affairs for that loved one who's maybe not able or doesn't have the capacity to handle those legal affairs on their own, either while they're minor. I have clients who have loved ones who are disabled, and they will not be able to handle their legal affairs even after they reach adulthood. I have clients who know that their loved one will need care, medical care and treatment and assistance for their entire lifetime because of disabilities, even after my client has passed on. And so these documents, the will and the trust, allow you to set up now and prepare now for those eventualities in the future and caring for those loved ones and using your assets to do so. Okay?
Okay. So I wanted to establish that first. And you were talking in depth about wills. So you could go back to that if
So what a will is five things. It's a legal document. It's signed by someone who has mental capacity. You cannot do a will if you're under a disability or under a restraint or under a mental disability where you don't have mental capacity. You know, we talk about sound mind and body. Okay, that's what they say in the movies. You have to have a sound mind. If heirs come in and they did not receive gifts under the will and they're disgruntled and they can prove that you did not have sound mental capacity, that may be a circumstance under which those relatives can set aside that will, can disavow that will, or can get a court to quash that will. Okay.
Okay. Remember that. Now, with a trust, do you have to be of sound mind to sign that document?
If it's a testamentary trust, if it's a trust that's going to take effect after your death, yes. If it's a trust that's going to operate during your lifetime, it's a little bit of a different standard. But again, relatives can come in and claim that this person was under a disability, they were under duress, they were threatened, there was fraud. I had a case where someone put documents in front of someone and told them they said certain things, but the documents didn't actually say what they were told they said before they signed it. So those are the ways that you can go to court and get a trust kicked out. Those are the ways that you can go if there's fraud, if there's duress, if there's coercion, if there's mental disability. There are a variety of different ways that a trust or a will can be attacked on that basis. Okay. But you've got to have, in most cases, you've got to have provable mental capacity. What does that mean? Doesn't mean you have to be a PhD from Harvard. What it means is mental capacity in this context means it's a very simple question. Do you know what assets you own? Do you know what assets you own? Do you know that you own a vehicle, own a car, own a home, own a bank account? Do you know that? If you know that and can prove that you know that, you may have the mental capacity necessary to do a will or a trust. Okay? Do you know the extent of the assets you own? Okay? So it's a document. It's in writing, can't be verbal. I've had so many cases where cousin Susie comes in and says, well, I'm not in the will, but everybody knew Aunt Sally wanted me to have that diamond ring. Everybody knew. Well, everybody knew doesn't work in this context. If it's not written down, it's not going to be legally enforceable. And the ring is going to wind up going into Aunt Sally's estate, and it's going to get distributed just like the other assets in her estate. Okay?
Okay.
But when I'm counseling clients on wills, I would say most of what I do is listening. I'm asking a series of questions. Why is it important to you to do a will? What assets and why is it important to you to provide for these individuals after your death or if I become disabled? We haven't yet talked about the healthcare aspect. It's very important. The healthcare piece, that's why people prepare. I would say 80% of the wills that I prepare at the same time, I also prepare something called a property power of attorney, which controls your property during your lifetime if you become disabled. And I also prepare something called a healthcare power of attorney. And that's the document. It's a companion to the will. It's a separate document, but they go together. The healthcare power of attorney tells how you want medical decisions made for you, usually at the end of life, if you're unable to make those medical decisions on your own. Most of my clients do not want, even those with substantial resources, they do not want those resources exhausted once their attending physician has given an opinion that she believes this will be your final illness. Okay? They don't want their estate exhausted in order to provide what we call extraordinary medical care. They don't want to be on life support. Okay? That can be hundreds of thousands of dollars. Many of my clients would much rather than spending hundreds of thousands of dollars on life support and extraordinary medical care at the end of life, if it's concluded that this will be their final illness, they would rather that money be set aside for their granddaughter's college education. Okay? And they'll put that in writing. And that's why we do a healthcare power of attorney. It allows you to designate what kind of medical care you want to receive, what kind of medical care you would not want to receive, at what point you want, I shouldn't say it this way, but I will say, at what point do you want to be taken off the machines? Okay? At what point would you like to be taken off of the machines? Okay?
Okay.
Because because you want that money to be available for your granddaughter's college education. You don't want that money spent to extend your life for an additional 3 months after the doctors have already said this will be your final illness. Okay?
And again, you call that healthcare
That's called a healthcare power of attorney.
power of attorney.
Healthcare
Okay.
power of attorney. It's the document that makes medical decisions for you during your lifetime once you've become disabled and are unable to make medical decisions on your own. And what the healthcare power of attorney does is, just like I told you, the will designates an executor to make decisions and administer. The healthcare power of attorney designates an individual, a loved one, a relative, a trusted friend. They will make medical decisions for you once you become disabled. Okay?
So
They
that's
will-
a whole different policy
It's a whole different document. The
document.
will is after death. The power of attorney operates during your lifetime. You're still alive.
Right.
You're still alive
Right.
for the power of attorney. It's just that you've become disabled and are not able to make medical decisions on your own. Okay? And one of the first questions that when the phone rang for me, when the phone rings at 2 a.m. and it's the hospital calling, the number one question that doctor is asking me on the phone, Steve, your client's been admitted to the hospital. Where is the healthcare power of attorney document? The doctor needs that document because he wants to know what medical treatment he can and cannot administer. And he wants to know who is the decision maker under the healthcare power of attorney to make medical decisions on whether we're going to operate, whether we're not, what medicines we're going to administer, what medicines we're not, and at what point we're going to discontinue medical care. Okay?
Okay.
So even though most people don't think about it that way, the healthcare power of attorney is a very important document. Everybody wants to talk about the will and trust. Nobody wants to talk about the healthcare power of attorney. Okay? It's the document that controls how medical treatment will or will not be delivered, typically at the end of life. Okay? All right.
Okay. I've heard of power of attorney, but not healthcare power of attorney.
You've heard of the property power of attorney, which allows you to designate someone to control how your business will be run, how your real estate will be managed, how your stocks and bonds will be bought and sold after you become ill and are unable to manage them on your own. But the property power of attorney is very important. I believe the healthcare power of attorney, which is a separate document. Those are two separate documents, the healthcare power of attorney and the property power of attorney.
I'm hearing this for the first time.
I believe they are very, very important, more important than people say. Some people talk about the power of attorney and they conflate it with or compare it to a document, what we call a living will.
Mm-hmm.
What a will is controls after death. A living will controls you're still alive. You're still alive. Okay. How is your medical treatment going to be handled? How are your assets going to be controlled? Are there going to be lifetime gifts made during your lifetime? Okay. That's a living will. So there's really a package of documents there's more to it than just the will. We talked about a trust to handle the real estate. We talked about guardianship. If there are minors involved, guardianship is very important. If there are minor children, they cannot execute legal documents on their own. They cannot buy and sell real estate on their own if they're minors. You may need to designate a trustee or a legal guardian to assist them. Okay. We talked about the property power of attorney as well as and separate from the healthcare power of attorney. But the questions, I'm going to say that most of what I do and have done for many years, the preparing of the documents is really just the final stage of what I do. Most of what I do is listening and counseling with clients and answering questions. A lot of answering of questions. What's going to happen to my business? What's going to happen to the car? What's going to happen to the family home? What's going to happen to my 5-year-old minor grandchild who I've been raising? Okay. What's going to happen to her? after I pass. And the doctors have told me that, I have clients, I'm going into hospice. What does hospice mean? Everybody knows what hospice means. Hospice is a special kind of nursing home and a special kind of medical care once the doctors have determined that these will be the final 6 months of your life. We're going to send you out of your nursing home. We're going to send you into hospice care because the doctors believe that this is your final illness and that your medical situation is terminal. By the way, on a lighter note, Karen, the good news is I've had clients who went into hospice because their doctor thought this would be the final 6 months. And at the end of the 6 months, they went home from hospice. Okay. So the doctor was wrong. My pastor likes to tell the story about one of his congregation. The doctor kept telling him this was his final illness, kept telling him, this is your final illness. You only have so many months. And as my pastor says, funny thing happened. That individual wound up outliving the pastor and outliving the doctor. So you never know how things are going to work out.
Right.
Just because your doctor tells you this is your final illness, that's not necessarily so. So you have to plan accordingly. But I get most of what I do is counsel clients. It's advising them. It's answering their questions. And I get lots of questions about healthcare medical decisions and the power of attorney for healthcare. I get questions about what this executor under a will, what can they do under the will? I guarantee you, it would be virtually impossible for you to spell out every single possibility of what could happen under your will. That's why you have an executor. The executor is there to make decisions about certain things, about your family company, the family business, stocks and bonds. You can't put all that into a document. The document would be 50 pages long. So you have an executor who's going to help make decisions. They're going to get instructions. I am an exec. I'm not only am I an attorney, but for some clients, I am the executor under their will. What does that mean? That means I'm the person that they designated, and I'm the person that they trusted to make sure that what their wishes were adhered to and followed under the will. The will gives me instructions, but it does not spell out each and every single thing that I have to do. Okay. So that's why they appointed an executor. You have to decide who's going to get those assets and when. There's the famous case. Some of your older viewers will remember the old actor and singer, Bing Crosby. He had a set of kids when he was young. He had married and had another set of kids when he was old. And he had another set of kids when he was quite old. And the story goes that his will designated that some of his children were not to receive a penny of gifts or cash or funds until they achieved the age of 80.
Whoa.
Now that's an extreme case, but obviously he did not he did not trust some of these kids' ability to manage money. I have clients who do not trust their children's ability to manage money. They worry that the money would be gone in a year. So they enter into a trust, they put the assets in trust, they designate a trustee or executor to manage and invest the fund. And I've had clients who said only a certain amount of money, $10, $20, $30, $40,000 will go out to that relative each year during their lifetime. Okay. And make sure that the money lasts for the entire lifetime of that child. Okay. So those are the kinds of things that you as the client, you have to determine that. Only you can decide whether your relatives or children or grandchildren are responsible enough to carry out your wishes or whether they are not. You can put all that into the document, all that into the will, all that into the trust. It can be referenced in the power of attorney and make sure that your wishes get adhered to.
Okay. My husband just typed a word, wrote a word, and he said debt. What about probate? What happens that things end up in probate?
Probate comes in two different ways. Number one, what the word means is it's to search and to verify. That's the purpose of probate. We want to search and find out if there is a will. Just because you prepared a will doesn't mean it got filed downtown at the probate court. It may have or it may not. It's valid whether you filed it downtown or not. It's valid if it's in your family Bible in the living room. It's still a valid document. If it was ever valid, it still is. If it was signed, if it was witnessed, if it was sound mind and body, if it was a written document, if all those things, it's still valid. What probate, and some people think probate is a dirty word. We don't want to wind up in probate. You need to do a trust so you don't wind up in probate. Well, you might wind up in probate, okay? And here's how. You're going to wind up in probate because there are going to be people who got gifts under your will and they're happy. There may be people, relatives who didn't get any gifts under your will and they're not happy. So they want to get into probate. They want to have the probate judge look at these documents in the will and determine, and the purpose of probate is to determine, is it a valid legal document? I may be one of your relatives. I don't really like or trust this will. I don't even think this is the valid will. I don't, because I didn't get anything. So it must not be valid. I think there may be another will out there somewhere that does give me some gifts. You've seen the movies. People are sitting around the table at the lawyer's office. They're reading of the will. Half of them are real happy. Half of them are not happy at all, okay? Because they did not receive. The next step for those unhappy ones is they're going to probate court. And they're going to try to disprove and invalidate that will. What probate does is it allows the judge, the probate judge, to collect the documents, review the will, take testimony, have hearings. That's your opportunity to go in to court and prove that this will is valid because I'm getting all these great gifts under the will. And for those other folks, probate is their opportunity to go into court in front of the judge and prove this isn't the real will because it left me out. It couldn't have left me out. She would have never left me out. So it must not be the valid will. Probate is your opportunity to go in and tell your story, tell your side of the story to the judge. Okay? And the judge in probate will go ahead. Go ahead.
No, I'm just okay.
Go ahead. What were you going to say?
No, I didn't have a question. I'm just saying,
At the end of that
you're,
process,
you're actually clarifying this.
You get to introduce documents. Yes, Judge, this is her valid signature. See, matches all these other signatures on her bank account. Look at all these signatures on these stocks. See, Judge, this is the valid signature. Yes, here are letters. She told me how much she loved me. Of course, she was going to leave me her house. There's not even a question. Okay, it's the opportunity of those other relatives, the angry relatives, to come in and say, Judge, look at this document. That's not even her real signature. It's not even a real, look at this. This is a mess. Judge, please throw this will out. It's not, I got people coming in saying that this will doesn't even sound like anything she would have said. Okay, please throw out this will. Okay, that probate is the process whereby you get to produce testimony, you get to produce witnesses, and you get to produce evidence that this either is or is not the legal will. Okay, you get the chance to do that. But once the judge rules on the probate and once he decides that it is valid or is not, then that's the end of that. And the executor will start administering and carrying out the wishes under the will. That whole process of introducing the documents, standing before a judge, getting the judge to rule, I had to go in and get the judge to appoint me as the valid executor to carry out powers. That whole process and that final court order, that's what we call probate.
Okay. All right.
Okay. That whole process. And it ends in a final order. It can take a long time. It can take a long time. Probate, depending on the complexity, depending on if assets have to get sold, depending on if there's a family business that needs to get sold, probate can take years. It can take years. Okay? And there's a lot that goes into it, particularly for people. It's not going to take years if you've got people of modest means, of modest assets. But when I've had complex estates, they have substantial assets, substantial estate taxes. They have family businesses that are owned, family real estate that needs to get sold. That can take years. Okay.
Oh, okay. All right.
All right. So
Oh,
that's the snapshot version of probate. I'm going to conclude. I'm not going to go further in this talk without
okay.
saying a little bit about what happens when there is no will. What happens when someone passes and there is no, that is its own structure. It's a framework. It's designated by statute in Illinois and elsewhere, and it has a name. It's called intestate succession. Intestate succession is how your property gets distributed if you die without a will. Okay? We don't know how you were going to distribute your assets, but if you don't write a will, and I say this all the time, if you don't write a will and you don't tell the world how you want your assets distributed, the state of Illinois will tell you how they're going to get distributed by statute. Okay? So they're going to go to your living spouse. 50% to your spouse, 50% to your living children. If there's no spouse, 100% to children. I mean, I can walk you through the entire framework. I don't want to do that. I don't want to talk to you, and I don't want to counsel you, and I really don't want to advise you about how your assets would be distributed without a will. Your time would be better spent, and my preference would be to sit down with you and prepare a will. And then we don't have to worry about what happens if you die without one. Okay? So I try not to spend a lot of time talking to people about what happens to their assets after they die without a will. Unfortunately, I have a lot of cases with clients where they already died. The grandparent died without a will, and it creates severe problems. I have attended seminars. I've given advice. You wouldn't be surprised to know, Karen, how many people in, I'll just say, Chicago, Detroit, and Cleveland just happen to have grandparents in Mississippi, Arkansas, and Alabama who died without a will. You'd be surprised. Okay? There's an entire process that we have to go through. If your grandfather in Texas died without a will and he just happened to own 200 acres of farmland, okay? There's I had to get certified. I had to get trained on how to assist people in that situation. It has a name. It's called heirship property. And it creates severe problems when those elders, I'll just generalize and say many of them are in the South, Alabama, Mississippi, Georgia, 100 acres, farmland, timberland, died, and they never had a will. Okay.
So maybe we should be looking into what our I'm getting this feedback right now. Let me do this. Maybe we should be looking into what our parents own. I have no idea of what my parents own.
And my current client here in Chicago had no idea that her father owned a massive amount of farmland in Arkansas. She had no idea. She wasn't worried about it. It didn't concern her. She was busy living her own life. He owned this land. He didn't talk about it a lot. He was wealthy, pretty wealthy, but that's not something he talked a lot about. And she did not find out about these hundreds of acres in Arkansas until he died. Okay? So that's a great point you mentioned. Nobody, and I feel I can say this without fear of contradiction. Nobody wants to talk to their parents and grandparents about after death. Nobody wants to talk. Nobody wants to talk to their grandparents about it. And I guarantee you, your grandparents don't want to talk to you about it. Okay. The problem is a lot of these things go unattended, and it can create tremendous, tremendous problems. Okay. If property is not in the correct title, if the individual passed without a will, if they did not leave proper instructions on how the property should be dealt with, you need to have those conversations, and you need to have those hard conversations. No one lives forever. Nobody here is going to live forever. And as difficult as it is to talk with parents and grandparents about their wishes after death, I strongly, strongly encourage you to do your best, to the best of your ability, to have those conversations with them, because it's going to create a mess. And it's going to, at least in my family, none of those grandparents want the children and the cousins and the nephews fussing and fighting about who's going to own what and going into court and hiring lawyers. I'm happy to have you hire me as a lawyer, but I don't want to be your lawyer in that context, because it's a pain in the neck if you've got relatives fighting against each other in court and in probate court. It's a mess.
Yeah.
And it's avoidable. It's avoidable if those elders took the time to prepare a will and they just realized, I don't want to do this. None of my clients want to think about after their death, after their demise. They don't want to think about that at all. They don't want to think about it, don't want to talk about it. But you have to be the adult in the room and force those elders to come to terms, have those conversations, prepare the wills and the trust.
That's so true. I mean, as my dad would say, we all have a day. We all have a day. And so we need to prepare.
And I have clients now, well, I'm not going to do it because my sister will do it. I'm not going to do it because my uncle will do it. No, your uncle's not going to do it. You have to have that conversation with granddad, because if you don't do it, it's not going to get done. I can't tell you how many clients and cases I had where one relative thought, I didn't think I needed to have a conversation with the elders about wills because I thought somebody else in the family was going to do it. Nobody else in the family. If you're not going to do it, nobody else is going to do it. I've got a client right now, land in Mississippi, homes in Mississippi. None of those siblings want to take the lead. None of them. And it's going to wind up intested, and it's going to wind up, that case is going, unless they do something, that case is going to wind up in Mississippi probate court. And that's not any place anybody wants to be, because their wishes are not going to be adhered to. It's going to go as the Mississippi state statute says it's going to go, to the spouse, to the children, to the siblings, to the parents. It's going to go exactly as the statute says. And I guarantee you that is not particularly the way that elder would have liked for it to have gone.
Okay. Well, this is good for seniors to know, but it's definitely good for the younger generation to know. As people, we need to learn how to live. Young people need to learn how to live now for when they get older. So we'll be taking care of things when we get older.
And in addition, again, if I could say one thing, it would be do not rely that someone else in your family, some other sibling, I don't have to do this. I don't have to have this conversation. I don't have to encourage those elders to do a will or because someone else in the family will do that. No one else in the family will do that. And if you don't do it, it's most likely not going to get done. Why can I be so confident in that, in making that bold statement? Because the same way you think somebody else in the family will do it and will help the elders to complete it, other people in the family thought that you would do it. And that's how it gets, and that's how it doesn't get done, because everybody else thought somebody else would do it. Okay?
Okay.
So years go by, things happen, and so many years go by, and it just creates tremendous problems. And I'll say it even because of the training that I did At one time, African Americans owned over 16 million acres of farmland in this country, principally Alabama, Georgia, Mississippi, Florida. You know the story. That 16 million acres, because of land loss, because people died without a will. And if you die without a will, it's much easier for that rich timber company to come in, or that rich oil company to come in and scoop up your land because you didn't do a will. So now, after 16 million acres of farmland, we are now down to 4 million acres of African American owned farmland in the US, from 16 down to 4, primarily because so many of those seniors in Alabama, Mississippi, and Georgia, they decided that they would die without a will.
And some of them didn't know to make a will.
They didn't know to do it. They thought, I mean, I'm just being honest. They thought, I know I'm going to die, but I'm not going to die now. And I don't really like lawyers, and I don't really trust lawyers anyway. And I don't want to talk to any lawyers. So, and they're expensive. So that's 2 reasons why I'm not talking to one. A, I don't like them. And B, they cost a lot of money. Okay? So whatever you can do, and anyone watching, to encourage your relatives and your elders to undertake this task, let someone know what you own. Let someone know in your family who you trust what your wishes are as to the land. Let someone know how you'd like to see it administered. Remember, a will, as I said a while ago, a will doesn't have any legal effect until after death. It's still your property. It's still your property 100%. And again, I keep quoting my pastor, don't be afraid to do a will, because, the story of the 2 old men sitting on the bench, on the park bench, saying, well, Johnny passed away. He was really rich. He passed away. How much money did he leave behind? And his friend says, all of it. All of it. So none of us is taking any of this stuff with us.
That's the truth.
You can be afraid. If you don't want to do a will, you don't have to. But but the reason you don't do one should not be because you think you're taking it with you. Because I'm here to tell you, you're not. You're leaving. How much of it are you going to leave behind? All of it. All of it. Okay? You will have, at that certain time, you will have no use for it any longer. You don't care how many acres you have. I don't care how many stocks and bonds you have. I don't care how many bank accounts you have. At that certain time, you're not going to need them. You won't need them anymore.
That's okay? Right.
So be very. I'm joking just to add a little lighter moment, but be very thoughtful and be very attentive. Have the conversations. They're difficult conversations to have. That does not mean you should not have them.
Right.
Have the conversations about medical care. We were talking about that in the first half hour, about what medical care you would like and what medical care you would not like to see. Have the conversation about who you would like to make medical decisions for you. Have the if you're unable to make them for yourself, because your doctor and your hospital is for sure going to want to know. They are the first phone call I'm going to get about you, if I'm your attorney, he's going to want to know where is the medical power of attorney. The doctor and the hospital want to know what they can do, what they cannot do. Did you want treatment? Did you want organ donation? Organ donation. Check the back of your driver's license, if that be what your desire. That's up to you. That's between you, your doctor, and your pastor. Okay? That's between you, your doctor, and your pastor to decide how that should be administered. Okay?
Okay. All right.
So again, as far as I said before, estate planning is just what the name suggests. It includes your last will and testament. It may include a trust during your lifetime. It may include a testamentary trust where assets get put in trust for maybe minors or disabled people to be administered after your death. It includes a property power of attorney, includes a medical power, healthcare power of attorney. It can include real estate transfers, authority to sell assets, transfer on death at your bank. At your bank is more to it than just a signature card and being a co-signer. There's more to it than that. Being a co-signer on your checking account, you have the power to designate a transfer on death and tell what happens to that checking account after your death. Okay? Transfer on death. Very important. I would say there are about 7 or 8 different documents that I would like to see in your estate planning package to have a complete. And the good news is, and the main reason why you should never be afraid to do the things I'm talking about, every single thing that I've listed today, from the will to the testamentary trust to the lifetime trust, lifetime gifts, powers of attorney, every one of those documents has the ability by you in the future to be amended or modified. Okay? You have even once you sign and complete these documents, you can change your will. We call it a codicil. A codicil. It's an amendment to your will. Not only can you change them over a period of time, I encourage you to change your will periodically, at least once every 5 or 10 years. Why? Why should you change your will, update it every 5 or 10 years? Because every 10 years, some children got born, some elders passed away, some people got married, some other people got divorced. It is in your interest. It is in your interest, in my opinion, to update the will and those documents at least once every 5 or 10 years, because so many things may have happened. You may have new beneficiaries right now, 5 years later, because several children got born since the time. You now have grandnieces and nephews that you didn't have 10 years ago, and you'd like to include them. Okay? And sadly, yes,
property,
unfortunately,
your
sad to
assets.
say, yes, I'm sad. I must say, just like you have grandnieces and nephews that you did not have 10 years ago, unfortunately, you also have uncles and aunts that you had 10 years ago that you no longer have.
Right.
So that's why it's in your interest to update the document. You don't want to have a will giving gifts to people who are no longer here. That creates confusion. It creates a lot of animosity. It creates problems. Well, of course, Aunt Susie passed away. She was in the will. Of course, he would have wanted me to get that if Aunt Susie passed away before he did. Well, of course, nothing. Not of course. That's what will land you in probate court. Okay? That will land you. Those are the types of things. Having people pass away, having gifts made to people who are no longer with us, having children born after your will. Those are exactly the kinds of things that will land you smack dab in probate court. Okay?
Wow.
Bear that in mind.
Okay.
All right.
Well,
so
this was very
I would say
interesting.
the things for you. I would say the things, so many considerations, and these are the things that I counsel people on. Please don't go to the folks who say, "Oh, we can do a will for $99, move it, you'll be out of here in 10 minutes." Well, again, if you remember nothing else I said today, good work ain't cheap. Cheap work ain't good. The point of this exercise is to include as many different potentialities and as many different contingencies as you possibly can. Leave as little to doubt. If they're beneficiaries and relatives who are important to you, and if it's important that one of them have the family home or have that bank account or that they get the family business, you should be prepared to step up and say that in the will. Say it. If you're not willing to step up and say that and put it in a will or document, what you're really saying is, I'm prepared to let the state decide how my assets will be distributed by law, and I'll just let things happen as they may. Okay?
So let me ask this question.
Those are the basics.
We're running out of time, but let me ask this question. Can someone write up what they call a will. I want this to go her and this to go to him and this to that. Have it notarized and that be considered a will?
No, people think that getting it notarized is what makes it legally valid. It's not getting it notarized, it's getting it witnessed. A will in Illinois requires that you sign it and that there be at least two witnesses who saw you sign, and they signed the will as witnesses. A lot of people get their will notarized because they want to do so. They get it notarized because they want to do so. They're required, witnessed, and notarized. A will is not required to be notarized. It is just required to be witnessed.
With two,
But people
two
get, I have lots of clients who, well, I'd like to have it notarized just because it makes it look more official, makes the will legal, and that's enough. There. Again, the will is not required to be notarized. It's only required to be witnessed, two witnesses. The power of attorney for property and healthcare, they're required to be notarized and required to be witnessed. Okay?
Okay.
Just keep, if you can keep that in mind and, make sure that you provide all the detail that you need that is required. Make sure that the will carries out your desires. And if I could say nothing else, make sure that you go back and revisit the will from time to time, every 3 years, every 5 years, as the case may be. If you've had a health event, let's say you've had a health challenge or a hospitalization or a illness, a major illness, or you got married, right? Or you got divorced. That's an excellent time to go back and revisit your will. Okay? And you can make changes to it. You can modify it. You can update it. The will, the trust, the powers of attorney, all of those life events, birth, death, marriage, divorce, illness, all of those life events are excellent opportunities. It's a wake-up call to you. Those are wake-up calls to you. When the doctor tells you you're going to be fine, but you're going to need to go into the hospital for a while, but you're going to be fine when you come out. That's an excellent wake-up call for you, telling you I should do a will or I should update the will I have. Okay?
Okay. Well, thank you so much. Thank you so much for the information that you've given us today. It's a wake-up call to many. It is, I've heard a few things, but I've heard a lot more today. And so I thank you for that. And I pray that people take advantage of that, not just seniors, but everybody. I pray they take advantage of the information that you've given us for today.
Because it's an area that I spend a lot of time in, my friends in Chicago and Detroit, who I know and have a bunch of relatives down in Mississippi and Alabama, and that's true. Do not let them off the hook. They need to have a will. They're not going to want to do that, but try to explain to them some of the problems that they could lose, and the property could be lost to the family. The property could be lost to the family if they don't prepare and complete a will. And they do not want the family to lose those 100 acres in Alabama. They don't. Amen. They want that to stay within the family.
All right. Again, I want to thank you for joining me today and giving us this information. And should you want to get in contact with Attorney Steve Lawrence, there's his information right there for you. And again, we thank you so much for joining me today. This is Seniors Navigating the Change, and I want to navigate life changes with you. So make sure you join me every week as we talk about various things that are happening with us in life as seniors. Now, this week's lesson, this week's conversation was good for seniors as well as our young people. so you know what to do, so you can plan ahead better. All right. Well, thank you so much for joining us, and make sure you join us next week. I think we're going to be talking to some retired people who are trying to figure out how to make it work. All right. Thank you so much. God bless you, and stay in God's care.